Ladies and gentlemen, 11 crore rupees. That is the moot point today. 2 years back, the Supreme Court granted this astronomical amount as compensation in the case of medical negligence. As you are aware, this was a case that spanned the breadth of the country from Kolkata to Mumbai. Multiple hospitals involved, multiple people involved, all due to the death of a young lady. The judgment not only resulted in a sudden rise in compensation granted by courts, but also in a corresponding increase in the cost of healthcare, doctor-patient distrust and apprehension amongst doctors and hospitals. And needless to say, the media played its own murky role in all of this by highlighting this 11 crore rupees as if it's some big deal. Somebody has lost a life. I'll tell you, as a group of hospitals, we have increased our coverage from 7 crore rupees as indemnity malpractice for the group to today to 25 crores. And that is adding to the costs of healthcare because obviously we have to increase our revenue generation somewhere. Two important questions that need to be answered in this context. Can a country like ours, a developing country today, and our healthcare mechanism afford such huge compensation to be paid out? If not, what is the best possible solution? The other thing is today's society is discussing various means and measures to address this problem. Bringing in a law to cap the amount of compensation to cases of medical negligence is one solution that is gaining support as an optimum solution. Filing a PIL in the Supreme Court, having special medical tribunals or compulsory referral of all cases of medical negligence to alternate dispute redressal mechanisms are a few such suggestions. The questions that we would like to understand: is the government acting upon this? Is capping compensation realistic? And is it a good option? What are the other options that need to be explored? I'd like to invite the following esteemed faculty on stage. Dr. Alex Thomas, who is the President of the Association of Healthcare Providers of India. Dr. Alex, please come on stage. Advocate Mayank Shirsagar, Advocate Supreme Court and an Associate at the Med Legal Attorneys. Pratmesh Popat, Accredited and Certified Moderator. Advocate Samuel Abram from Vellore, who is the Legal Head of CMC. Okay. But I'm going to start with a video presentation, and I'd like lights to be dim, please. I'm going to start with a video presentation by none other than Dr. Devi Shetty, who, as you know, is a very renowned cardiac surgeon who has done a lot in the country to bring down the cost of cardiac surgery, especially in the pediatric cardiac domain, as well as started various schemes across his state and wherever his hospitals are located. That is a Narayana Hridayalaya group of hospitals. I'd like you to please listen to Dr. Devi Shetty. He has a small note for us. Dr. Alex, can we play Dr. Devi's presentation, please? Yeah. Ladies and gentlemen, in lieu of the batata vada that just went in, we are restricting the next 2 sessions to 35 minutes each, because today being Dahi Handi, those of you who have to catch flights would definitely need to leave this premise by about 5:45. Okay, in case you have a 7 o'clock flight or thereabouts. So something Krishna Bhagwan is on your side today. You're lucky.
Ladies and gentlemen, good morning, ladies and gentlemen. I'm very sorry I couldn't be there personally to interact with you. I would like to discuss with you about a major crisis which is going to have a big impact on Indian healthcare. This is about malpractice compensation, huge malpractice compensation. Few years ago, Supreme Court slapped about 10 crore rupees of compensation for the death of a patient which occurred in a hospital in Calcutta. It is very unfortunate that the patient died, but a compensation of large sum of money to the tune of around 10 crore rupees will automatically result in lower courts increasing the current compensation from lakh rupees to crore rupees. If that happens, believe me, most of the 30-bed, 50-bed hospitals where majority of the children are born are going to close. A gynecologist working in a small town is perhaps the only safe place for a child to be born in that area. Unfortunately, if an incident happens, if the lady dies or the child dies following the childbirth, if there is a litigation, a simple compensation of ₹1 crore for the death can ruin the entire fortune of this doctor. If the doctor sells his nursing home, house, and if he has any farmland, also, he or she may not be able to come up with ₹1 or ₹2 crore. Death is unacceptable by us or by any other country. The question is, do we have the capacity to pay huge compensation what is expected by the society today? Unfortunately, our patients simply do not have that kind of money to pay for the treatment. In the process, most hospitals are barely able to survive, and good number of doctors earn enough money to lead just a basic existence. If we add this risk of huge compensation, there will be a huge migration of doctors from small towns to big cities, and they will be comfortable under the protection of a big hospital where a large legal team can work full time to protect the doctors. How can a 30-bed, 50-bed hospital afford to have a big medical legal department? Do they really have electronic medical records? Do they have even a storage space to keep their medical records? We are aware that when there is an inquiry in the court of law, what protects the doctor is the documents what he has created. Today, because of the acute shortage of PG seats, virtually there are no young doctors to assist these senior gynecologists and surgeons. Most of these nursing homes are run by, it's a one-man show. They can't afford to have a second doctor. They simply don't earn that kind of money. We are also aware that most of the schemes which all the governments are launching, which we welcome, are hardly paying enough money to make both ends. So, if we are trying to create a first world regulatory structure with third world infrastructure, most of the hospitals are going to close down, and most of the doctors will migrate from small towns to big cities. And this will be the end of healthcare for 65% of the country's population who live in rural India. It's a serious issue. We have to try and cap the malpractice compensation like what they have done in the US. If in the United States you cannot sue a doctor for more than ₹1.5 crore, what justification we have in this country to sue a doctor for ₹10 crore? Where is the income? How much a doctor in the US earns and how much a doctor in India earns? Is there a comparison? Whatever is happening is not going to help anyone. It is not going to help doctors, and it is not going to help the patients. When I was a young medical student many years ago, Consumer Forum was created, and they started inquiring into the doctor's practice. At that time, if all the doctors got united and protested, we could have come out of the consumer court. But we didn't do it, because all of us thought that it is not going to happen to me, it is going to happen to somebody else. Believe me, the way people are getting educated, literate, it is a matter of time before we will become a highly litigant society. In that kind of a scenario, if there is no capping on the malpractice compensation, all of us are going to suffer. We now have a great opportunity to come together and convince our policymakers that capping is a standard norm in most of the developed countries and we can't be an exception. And unless we are united in this effort, we are not going to succeed. My request, humble request to all of you is to come together. Today in city of Bangalore, if an auto driver is harmed by the police or by the people, in few minutes all the auto drivers of Bangalore city come together and protest. But if one doctor gets hurt in whatever way, physically or legally, all of us think that it is not my problem, it is somebody else's problem. Before it becomes your problem, let's come together and ensure that fair deal is offered to medical professionals like us. Otherwise, believe me, medical profession will cease to be an attractive profession for the future generation, and this will have far-reaching consequences. Thank you once again. I'm extremely grateful to you for the opportunity.
Lights, please. Dr. Alex Thomas for the keynote address.
Good afternoon to you. I'll run by a bit quickly because Parag has already warned me that we have 5 minutes has been taken away. I'll start off with a scenario, a very realistic scenario in the state of Karnataka. A 30-bedded maternity nursing home run by a single gynecologist slapped with a consumer case. Over 2 years, numerous court hearings, travel, tension. The consumer forum awards the patient 50 lakh compensation. The nursing home shuts down. So as my good friend Dr. Saini was saying, who does it benefit? It doesn't benefit anybody. The doctor has closed shop. The community suffers because there is no facility there. In fact, the patient who has sued will have to travel 100 miles more to get medical care. What is the situation in India today? I think we have to accept a few things, and this is what I'm talking about is what we had as a national steering committee, which I'll talk about a little later. We have to accept that there are unethical practices, there are unnecessary referrals, unnecessary procedures, unnecessary surgeries, all to meet targets, either management targets or personal targets. And I think we should also remember, in addition to the sword of the clinical establishment hanging over us to regulate prices, there is also, over the last year, a private member's bill pending to be introduced, where the member has said that because of this unethical practices, and she says 90% of the people, medical fraternity is corrupt, government needs to get in, we need to regulate, we need to tell them what they need to charge as consultation fees, we need to tell them what to charge. So I think with these two things hanging over our heads, we need to be very careful and we need to self-regulate ourselves before somebody else decides to regulate us. What about our younger colleagues? I was maybe a month ago talking to a super specialist who had just passed out, and I was talking to him and I was amazed. He had passed out from a capitation college. He had got a job in a medical college. He said, I'm going to start private practice, which is not allowed, but didn't matter to him. And his calculation was, I'll send at least 2-3 scans, I'll get X amount. I'll send 2 MRIs, I'll get X amount. Lab will give me so much. So it is amazing that this culture has gone to the younger generation, and I think all of us are responsible for it. We generally forget that we have taken this Hippocratic oath that a patient is first. And if you go into details, I can talk hours and hours about it. Why is this happening? The system in our country is corrupt. You pay 6 crores for a radiology seat. You pay 1 crore for an MBBS seat. And the first thing that he looks for is when will I get my return on investment. So there are a lot of other things that we have to look at when we talk. And of course, we all agree that the image of the medical professional has never been lower in our country. Very unfortunate. And we have done a study on communication skills, and it has been established that poor communication skills are the main cause of litigation. And studies in the Western world have shown that 60 to 70% of medical errors, not anything, medical errors, 60 to 70% are due to communication and are completely preventable. And very important, you may say, oh, communication doesn't matter as long as it doesn't impact outcomes. But a very widely respected study has shown that outcomes are related to communication. I'm an orthopedic surgeon, and traditionally in our country, orthopedic surgeons are supposed to have the worst communication. We are not taught about this in medical college, we just learn from our seniors. So I think it's very important that this is also addressed. As in our maybe 10, 20 years ago when I finished medical school and started practicing, and many of us seniors here, doctors were on a very high pedestal. But as was mentioned many times over and over again today, there is a trust deficit. And I think it is vital when we talk about capping that we have to bring back this trust and to be patient focused. The other thing about us, and as Devi was saying, is that if something happens to somebody else, we don't worry. If a nursing home is attacked, we all sit aside, and in fact the neighboring people will be very happy that a nursing home has been attacked. I think that has made us soft targets, and I think our Maharashtra colleagues have showed the way forward, how they've got together and done a lot of things. During attacks, no support is received, and India is the only country, I think, where erring doctors, my lawyer friends can correct me, can be brought before multiple forums for the same offense. I was at a conference last week where there was an example of a patient taking a doctor to 22 different institutions, the Lokayukta, the State Human Rights Commission, National Human Rights Commission, the Criminal Court, the Civil Court, etc. But however, this unity, these things are changing now, and I will just give you a few examples of from my home state of Karnataka. We were able to, the Association of Health Providers was able to get all the hospitals together, and we were able to convince the government of Karnataka to give the hospitals a separate tariff for electricity. Earlier we were on a tariff with bars and dance halls and cinemas. We have been able to, a few years ago, convince the government of Karnataka to bring out a rule saying that assaults on doctors and medical institutions are non-bailable. We've been able to have some progress with the CGHS, and for the first time in the history of CGHS, based on representations of AHPI through hospitals, they have changed a few rates. And I also want to say that we have got together regarding the PCPNDT Act, which was mentioned, and I'll just spend a few minutes on this. The AHPI and the IMA got together, and we got all the stakeholders together. Unfortunately, before this, associations amongst ourselves were fighting with each other because there were differences of opinion. So they're on a common platform now, and we've been able to represent to the health minister, to the law minister, to the central supervisory board, and we hope that things will change soon regarding the criminality aspect of the law, and also to make use of ultrasound widely available for the country at large. Now, we also have to look at various options, and I'm talking again from the consultation we had recently. And I think what is important is that we need to provide quality care at affordable cost. It has been said many times earlier, I won't go into it. But it's also important that we professionals have a good working environment. And I can say that in most of the places in the country, taking up the job of a clinician is not very happy. There's always tension. There's always feeling in the back of the head, when will I be attacked? When will I be sued, etc. And the present system, as we all know, doesn't enable either of the both the consumer forum and the courts takes a lot of time, and it is increases the cost of healthcare. Now, we cannot look at compensation in isolation. We have to put all these factors together. We have to, as I mentioned earlier, we have to try and be patient focused and get the patients on our side. We must review ethics and legal practices in the medical profession as a whole. In June 2015, we had probably the first of its kind meeting in the whole country, where we had, again, it was the AHPI and the IMA, and basically it was brought together to talk about capping. But, and we had all these organizations, all the major societies, all the hospital societies. It was a 4-hour deliberation and came up with a lot of very good ideas, which I'll share with you. Before going into that, a quick history of capping in the developed world. In the USA, there is capping, and it had been taken to court, but it was upheld. And one of the reasons was rising insurance premiums, short physician supply, defensive medicine, and a lot of frivolous litigation. In my state of Karnataka, since in the last 18 months, consumer cases have increased by 42%, which is very, very significant. And I'm sure it's the same in all the states. In the UK, and I think this is relevant because how it has pushed up the cost of healthcare. In the UK, when they were doing a study on capping, they discovered that defensive medicine really pushes up the cost of healthcare. Unnecessary tests were ordered almost 60% of the time. Unnecessary referrals, 55%. And this is because we want to protect ourselves. Avoiding high-risk procedures, 18%, and senior doctors practice less. Australia, which has the highest rate of medical error, also has a cap. And just to summarize, what would be the merits of capping? As mentioned here, I think Parag's hospital, the premiums have gone up 4 times. And I'm sure that is the cause. That is the same in all the other hospitals. Defensive medicine in India, I think if you look at it, it's probably 60 to 70%. And in a country like ours, where there is a shortage of specialists, we are only driving this shortage further. People are finding it more comfortable not to take up complicated cases, not to practice in specialties where there is litigation. And of course, as I said, frivolous litigation is on the rise. So this consultation that we had came up with a white paper written by Dr. Jogarao from the National Law School University in Bangalore. And basically, I'll just quickly go through that. Focus of our healthcare. And these were the associations probably represented all the major specialties. So we were talking on behalf of all of them and all the hospital associations. And one thing which came about was that focus of healthcare delivery, and we've been saying it again and again in different sessions, that it's always on patient safety, interest, and satisfaction. And if the significant goal to be achieved is ethical medical practice, aiming for quality care at affordable costs. And these were the causative factors which were identified at that consultation, that there were a lot of unethical practices, options of multiple legal remedies for patient grievances, sometimes scant regard for patient rights by hospital and doctors. The world is changing, and I think we have to be aware of that. Medical litigation is the preferred choice for the patient. Insurance premiums have already been mentioned, and of course in the previous sessions we have been speaking about violent attacks by patients and willful default in bill payments. The other causative factors, education of medical negligence cases by non-medical members. And medicine is such a dynamic subject, and it's very difficult even for us to go into it. And I think one of the reasons we're getting all these judgments is because people who do not have too much background in medicine are handling these cases. Judicial orders for ever increasing quantums of compensation. And I think this was again mentioned, influence of insensitive media. Somehow, though I am from a mission background, I think the media always focuses on doctors, saying that we are making a lot of money and whatever we do, we are gypping the patient. So I think that also has to change. And the other important thing is that the state's dwindling budget and ever increasing private investment, which has again been brought out by the earlier speakers. Now, what are the recommendations? Setting a cap on compensations is one of the things we looked at. Amendments to the CPA, and Mr. Samuel Abraham will talk on these two a little more. The other options that we looked at for setting up of medical tribunals staffed by medical people, streamline the jurisdiction of forums so that one patient cannot go to 22 forums. That it's the options to be fair to him and also be fair to the other party to keep it limited. Introduce a penalty for false litigation, and something about a healthcare arbitration, which again my colleague will talk a little later. I'll just quickly talk about this mediation because it's something very, very important, and I think I have some experience. It takes a lot less time, it's very much less expensive, and both parties are satisfied with the few limited cases that I have, but we'll hear more about that later. Yes, and we need to ethically regulate medical care, I think it's important, keep the patient as a focus. A public campaign for the awareness of the above, and again, as at the cost of repetition, bring back the doctor-patient relationship, achieve high levels of patient satisfaction. Other recommendations were to set up ethical committees at the hospital level and explore how to prevent potential medical negligence. And here again, the key is communication. And quickly, I'll just go through two things which I think communication. We have brought out a book on Communicate, Care, Cure. This has been a runaway bestseller. We have had workshops. It's made a big difference. We were not able to satisfy the demand, so we've now come up with an e-learning module. But what I'm trying to say is that I think communication is something which is very important and will go a great way in reducing the number of litigation cases. So this white paper was ready, the draft of the white paper was ready yesterday. I will circulate it to the institute here and to the association presidents and to all who want to see it. Once it is finalized, we are planning to send it to our leaders, to the members of parliament, to the ministers. In fact, we've already met the health minister and the law minister. This will take a long time, and we look forward to your suggestions. So again, I think once we are patient-centric, everything will fall in line. And these 3 points will immediately bring down the incidence of medical negligence. Thank you very much.
Thank you, Dr. Alex. I'm going to request Mr. Pratmesh Popat to take about 1.5 minutes and give us his expert comments.
Soon turning to be a match on toss in 1.5 minutes. But I'll just take you quickly through a short example. Everybody uses mobile phones, so we'll take it from there. That you have an application which is opened up, maybe 2-3 of them. You can scroll by selecting an option of closing that application, going through the proper stages. Or you could just press the red button and you're out of the application. You think you're out of it, but actually it's still there running in the background, draining your battery life and also putting a strain on your processor. Your operations will be slower, and therefore you are going to be able to use that phone for much lesser time for the rest of the day than you could if you had properly followed the procedure. The same thing applies in real life where disputes are dangling like a Damocles sword. And I'll just give you one small example about conflict. An experiment was carried out in US. They checked up one doctor's diary. On a particular day, they saw he has only 5 minor surgeries, very minor, nothing life-threatening. On that day, early in the morning, he had a fixed parking slot with his nameplate on that. They parked one car in his parking slot and they left another parking slot right opposite vacant to ensure that he does get a parking spot so that he's not delayed. He parked it over there. On that day, at the end of the day, they found that all those 5 surgeries next day had to be revisited. Now just imagine, just a parking slot has been taken up by this doctor, by someone else of this doctor, and he's not able to perform even minor surgeries, all 5 of them. Imagine what would be happening to you when you are addressing life-threatening situations for your patients. All the more reason you need to be careful that you close all those windows and operations and applications that are open properly, procedurally and swiftly, so that there is no drain on your operations, on your capability, on your faculties. And that's where mediation comes in. In my over 2 decades of practice at the bar, I have done only one case, which I have been the only lawyer all throughout, and it has ended in 2.5 years. Otherwise, all matters, I just appear like a taxi driver taking you from here to there, and then it's somebody else's baby. So 2.5 years, only one matter I did, and other matters are still dangling for 5, 10, 15, 20 years. Against that, if you take a matter to arbitration, you still end up spending about 5 years, maybe lakhs of rupees on the arbitrator, getting dates and the lawyers along with that, paying for them too. And against that, if you now look at mediation, this is something which now even the courts are pushing under Section 89. So there is a legal framework for accepting that as a dispute resolution modicum. And mediation is different in this way, that the parties decide for themselves what is the outcome they want in this situation that they are before faced with. Now, if you are in arbitration, you decide the arbitrator and then the ball in his court, he will decide what will be the outcome. But the mediator only sits with the parties to get them talking and keep them talking. And ultimately it is through their talking that an outcome emerges. So as the saying goes, baat karne se baat banti hai, and the mediator is that there just to ensure that you keep talking till you get to a solution that you can live with. And that, gentlemen, is something which I would like to close with. But should we have any questions, I'm here to answer them. Thank you.
Thank you. The last time I started speaking, I had to get married, ladies and gentlemen. But anyway, that's neither here nor there. I'd request Advocate Samuel Abram for his views, please. 2 minutes, 3 minutes, with respect to the fact that you've come all the way from Vellore, sir. So if there's repetition, let's just skip over because we have one more session.
Sure. No repetition. It is completely different. I am going to take you a different area. It is a very pleasant area. Only advocates can appreciate very easily. You should also be an advocate now to understand that. Now you should be very happy that the consumer fora are not regular courts. They are tribunals, quasi-judicial, statutory bodies, not constitutional bodies. All the other courts, regular courts, which are having inherent powers, criminal court, civil court, they are all constitutional bodies. This consumer fora, after all, it is only a statutory body created by a statute which can be annulled, amended very easily. Number one, you can see there, all tribunals are coming under executive. All other courts are coming under judiciary. Please understand that. If it is judiciary, it is very difficult to touch. It is only a law. It can be annulled, it can be amended. There are many statutes were repealed. So be happy that consumer fora very easy to tackle. Number two, consumer court is a tribunal and it is only a statutory and not constitutional body. Tribunals are statutory bodies, whereas all courts are constitutional bodies. Legislature, parliament can specify the power. It is all delegated powers only. All the other courts are having inherent powers. Tribunals, you should act in this way only. Ceiling, maximum ceiling, minimum ceiling. For example, a municipality levies a tax. The constitution says no tax can be levied without the sanction of law. How a panchayat is levying a tax? Because there is a Panchayat Act fix the ceiling, maximum ceiling and minimum ceiling within which the Panchayat is empowered and delegated to collect the taxes. That's why it is not voted actually. The same way all the tribunals, debt relief tribunal, labor court, labor industrial tribunal, all tribunals are delegated powers. They don't inherit or take any powers from the constitution. You understand it? Tomorrow, if the parliament is cancelling or repealing the Consumer Protection Act, no consumer fora will be there. But regular courts will be functioning. That's the much difference. I don't have time. You can see that. Tribunals are exercising delegated authority. I am asking a person to go to Delhi to sell a house. After the house is sold, he does not have anything at all. Specified duty. This for example. Tribunals are conducting only summary trial. All other courts, regular courts are conducting regular trial. Summary trial means cut short method. No witness is produced. All witnesses are not produced. In a criminal case, 50 witnesses, 100 witnesses, 150 witnesses are produced, cross-examined. Here, instead of producing witness, we are filing proof affidavit only. Mostly paperwork. The final order passed by a tribunal are awards which require some time to reach finality. In a criminal case, when a magistrate writes signs, immediately it is effective. The chief minister loses their job. The government cars are withdrawn immediately. But in a tribunal, even if they are putting an order, it will take 30 days minimum to make it final. All are judgments, but the tribunals are giving only award. Awards can be passed. There are so many. Now, compensation. Quickly, how so far Parliament, listen to me, it is very, very careful. You should be very careful. How so far in this India, Parliament quantified the compensation in various law. One, Motor Vehicles Act, Employees Consumer Act, Employees State Insurance Act, serious adverse effects in clinical trial. Listen to me, in all these acts, Parliament, its own wisdom, I repeat, its own careful wisdom, fixed a sum for a doctrine we call restitutio interium. The meaning is, restitutio interium means a person is suffering, he should be restituted to the normal position. We had a fight with my wife. She went to her father's house. I am filing a petition, restitution of conjugal right. Please, the person is suffering, he is ill, he got injury. Please restore him to the backside. All these compensation cases, please understand, they are working under restitution of interium only, not the judgment or amount given by Kunal Saha case. A restitution, the matter ends. Now, for example, Employees Compensation Act, previously it was called Workmen's Compensation Act. You will be knowing, in an industry, a worker is working. There is no intention for him. There is no employee liability, but the fellow dies. The employer is expected to give, you can see, maximum 4,56,000. Maximum 4,56,000, minimum 1,20,000. That's all. The value of life, this man is working in an industry, even he dies, this much compensation is being given.
Resume slideshow.
Sorry. Next, employees compensation, state insurance. We are having insurance. There is no lump sum is given to the deceased. But in fact, the legal heirs of the deceased is being some pension regularly till they attain 18 years. Till they attain 18 years, regular pension is being paid, no other compensation. Parliament has enacted this law. Next, Motor Vehicles Act. Now, this Motor Vehicle Act, three aspects are taken to capture. One, restitution. The court is ordering reimbursement of actual bills. I repeat, reimbursement of actual bills paid by the consumer or patient. Two, loss of income. Because of this illness, he was not able to attend the work, loss of income. Three, this is the third, is the only area where judges are given powers to under his discretion. That is, one is fixed, second is fixed, third, loss of consortium, emotion, number of dependents, family size, family life expectation. These are subjective conditions. Taking into consideration of all these, the third factor is included. Even then, in normal cases, it will not exceed normally 15 lakhs or 20 lakhs. Very, very rarest of the rare case, it goes more than that. Please believe me, all these cases are compensation cases.
Sir, please wind up within a minute.
What?
1 minute.
Yeah, this is more than enough. Now, this is the case. Now, I have made the work very easier. I brought amendments very easily. Now, you can see, you can send it to the Legislative Assembly, get it passed. Parliament, get it passed. Now, you can see, district consumer is very, very important. Even if he is preventing me, I will talk. District Consumer Dispute Redressal Forum, Section 14. Now, existing is to pay such amount as may be awarded by it as compensation to the consumer for any loss, injury suffered by the consumer due to the negligence of the, this is existing. This is, sky is the limit for the judge. I am putting is a cap, provided further that the DCDRF shall quantify the amount of compensation to the complainant, especially in alleged medical negligence, by taking into consideration of the following factors: the actual reimbursement of medical bills, plus reasonable amount of incidental charges. See, tomorrow, Mr. Mukesh Ambani will come to my hospital. He will come by a Airbus or a very big flight, special flight. I cannot reimburse that. There must be a cap, reasonable expenses. Are you able to understand me? It should be prudent, reasonable. And the actual loss of income. Third, this is very, very important. Loss of consortium, loss of spouse, affection, comfort. These are language of the Supreme Court. Solace, companionship, society, assistance, protection, care and sexual relations during the future years to the complainant in case of death of the patient which shall not exceed, this is a discretion, 1 or 2 or 3 times of the total sum computed at A and B. A and B fixed, easy to calculate. Third, put a cap. Nobody can go against it. Now Dr. Kunal Saha can marry 3 or 4 beautiful girls because loss of consortium, loss of wife, you have given 13 crores for him. Very good man. And no dependent for him. No father and mother. No dependent children. He can enjoy life. Here is the difference. We have to cap. Second, this is for forum, district forum. Second, state consumer. The same thing, section 17B, we are putting a cap. You read that, same. Now again to National Commission, same, section 21B. Just we are adding a provision. If you are so strong, you can take this to the parliament, but I'll tell you, getting an amendment to a law, existing law is very easy. Instead of bringing and introducing a new law. Very easier. This is the very least. I am so happy to tell you this work is very easier. Here you have to make some wording. Actual reimbursement of medical bills plus reasonable amount of incidental charges. Incidental. You cannot come as a helicopter and reimburse. These are all 2 amendments already made in the Consumer Act. So it is very easy. We are going to have a 3rd amendment. That's all. This I have no time. Okay. These are all new additions of liability to the doctors.
Thank you very much, sir.
Thank you so much. Within the time I finished.
Not very factually correct, but we'll accept that. I'm going to give exactly 2 minutes to my good friend.
So most of the things are covered by my learned senior colleague.
So, sir, I would like you to dwell essentially on what changes you feel we as a group of people should be advocating to the current law.
No, I'll just give an example as to why and how that 11 crore figure was reached by the court. The court awarded 5.96 crore as compensation. And then there was the 9% interest which all accumulated to 11 crore rupees. Now, what all suggestions we can provide is there should be a cap for this interest to be granted by courts. There should be a there cannot be a straitjacket formula for computing the loss suffered by a man. That is why, as pointed out, the Motor Vehicles Act provides for a particular set of rules which are used for calculating compensation. If those are used, there has to be a cap as to what can be the maximum. For instance, and first of all, we need to remember that Dr. Kunal Saha's case was an exceptional one because the wife who died was also a doctor, the husband is also a doctor. So the factors which are considered as per the Motor Vehicles Act also include the income of a person who has died. So if the income exceeds, automatically the compensation has gone up. So that is the reason why that figure of 5.96 crore was reached. After that also, we need to, this has not stopped. There is another case in 2014 where the court has again awarded 1.8 crores to a government hospital, which was to be directed to be paid by state of Tamil Nadu. This is also done by Supreme Court recently in 2014, November or December is the judgment. So now, what all suggestions we can provide is, number one, there should be a cap. As everyone is agreeing, there should be a cap on the amount of compensation. Apart from that, there should be a medical insurance. The insurance liability should cover that cap. That way the hospital will be protected. That way the doctor will be protected. And the doctor needs to disclose, as a suggestion, it is coming from my side, the doctor needs to disclose to a consumer, to his patient, that this is my cap of compensation payable and this is the insurance amount payable. So at max, the doctor will lose the amount of compensation which he is paying an insurance premium for. So this is one suggestion. There are many which we can come as an outcome of our session and suggest the Parliament suggest the Medical Council, suggest the Ministry of Health to our recommendations which can come as a law or can be benefit to us.
I'm going to allow one question, and that question is going to come from me, because otherwise we will never complete. I'm sorry for being so Hitlerish, but I have one question. What do you think? I think Dr. Devi Shetty already mentioned it well enough. Are we at some stage looking at a scenario wherein we are going to, with our visiting cards to our patient, going to give on the reverse the address and the telephone number of our lawyers with the amount of our malpractice indemnity amount? Are we going to actually be talking about this in with so much ease? Because what I heard from Advocate Sagar is that basically we should be declaring at some stage to at least the hospitals. As of now, most hospitals in Mumbai have a cap of around 20 lakh rupees for most people whom they take on board. What is the amount? That's the question. What is the amount you believe will be appropriate for a professional to take as malpractice indemnity? And the question is basically to Dr. Ture, to Dr. Vasisht. Surgeons, physicians, both of you are surgeons. Dr. Saini, you also. I'll come back to you, sir, in a minute. What do you think should be the amount today of malpractice indemnity we should take as individual professionals? We will discuss the capping later. That's already been discussed in great detail. You're audible, sir.
Yeah, if there is no capping, like how it is now, you don't have the limit. It's very difficult to
Exactly.
know what is the limit that you are going to take. Plus, of course, it's going to depend on what faculty you are in. Depending on which faculty you are practicing in. Which city, which faculty, and of course, the type of patients that you get. As you said, if Ambani comes and something happens to him, I don't think the whole of the Mumbai city can pay for his...
Because if you look at the Kunal Saha case, essentially this is a case of critical care. This is not even a surgical case. This is a case of a dermatologist and a critical care working jointly with each other. Dr. Vasisht, any comments before I close the floor? Sir, I will have to close, sir.
I think we have to devise some sort of capping like what they have...
Which we discussed, sir. Which we discussed. All right. I'm going to close this meeting. Thank you very much, Dr. Alex, Mr. Popat. Thank you very much. Sir, we will continue later. And now I'm going to invite on stage